TGI Friday. I know I said there'd be a video Tuesday or Wednesday, but after that hearing, there was some other things going on. We had a board meeting on Wednesday, the expectation of arbitrator Ben's release of his opinion on the arbitration for termination cases. So I just decided to hold off and waiting to do a larger kind of explanation video on Friday morning. Here we are. Tuesday morning's hearing for the temporary restraining order on the healthcare increase was rejected. I'm going to boil it down to the simplest terms. There was a 4-part hurdle that we had to get over. Each part had to have a yes answer to it. We met the first 2 hurdles. The third and fourth were kind of intertwined, but the easiest way to understand it is the judge rejected the temporary restraining order on the basis that there was not irreparable harm if this was to go forward. He needed a yes, that we had to show that it was an irreparable harm. Financially speaking, he said this can be undone. It can be rewound. This 0.75% can be undone and refunded to all members who paid out that money starting this month. So that was why he rejected it. And he used the analogy that the difference between this and the COVID one was once the jab was in your body, it was in your body. That's why Judge Mitchell, rightly so, granted the TR order 2 years ago, or almost 3 years ago now. So onward we go with that. He did say he will issue or seeking a summary judgment in an order from that judge to demand the parties go back to our interest arbitration effective immediately to resolve this issue. The issue is and still remains that we have to have a conversation. It is a 2-part conversation. The city has tried to kind of meld this together and muddy the waters, and intentionally so and improperly, because they know what the conversations were. And that's why the attorneys who were part of the mediation arbitration process didn't say a word Tuesday. They let the other guy do it because he wasn't in those discussions. So I guess he can plead ignorance to the conversations. But our position and agreement has always been simple to understand. First, we had to have a conversation about what adequate savings was going to mean in relationship to the healthcare screenings that we had conducted. We could not release data and would not release data until we had an agreement. If we could not agree on the definition of that terminology, it would go to a mediator arbitrator for the arbitrator to decide what that terminology or whose version of it is the right one. Once that definition was defined, then we would release the data supporting our position that we had met that threshold. That was always the way this was supposed to go. The city wants us to give the data first and then have a conversation that if we met this threshold of adequate savings that has never been defined. It's like going to a car dealer saying, hey, I can afford $800 a month payment for a car. And then he tells you, okay, great. Instead of 6 years, you're going to be paying 14 years at $800. It's just a dumb way to do business. The city knows that. They've been playing a game with this healthcare all along because they never had any good faith intention on ever giving us the ability to provide proof that we can do this similar to what Philadelphia does and save our members money. Period. Full stop. So that's the healthcare one. I'll let you know what happens at the next court date with the demand for the expedited arbitration process to the summary judgment on that decision going forward. Fast forward now, arbitrator Ben yesterday morning issued his final opinion on the arbitration for termination cases. When we had our follow-up to the city council rejection, our dispute resolution panel conversation 2 weeks ago, it was pretty clear that he wanted some time to craft a very detailed final opinion. And we knew it wasn't changing as far as his position, because literally the way the dispute resolute panel works is very simple. I am one member on behalf of the lodge and membership. Cecily Porter is one member on behalf of the city, and Ben is the third. Two out of 3 rules all of these things. So the arbitrator was very clear he was not changing his position, even when before he issued that final award months ago. So we knew that nothing was going to change. But I have to tell you, the link is on our website. If you want to read it, it's the most scathing arbitration opinion for one party that I have ever read personally. Someone could prove me wrong, I'm sure, but I highly doubt it, because in that award, He absolutely and rightly so says that Mayor Johnson and every single one of those aldermen who voted no violated their constitutional oath of office to uphold the Illinois Constitution, which does include labor rights and labor law. They do not get to pick and choose what laws they want to uphold. They're no different or any better than the state's attorney currently of Cook County, who has arbitrarily decided what statutes that she thinks needs to be enforced, what thresholds for shoplifting and other things need to be enforced, and what ones can be ignored. That is not what a constitutionally elected officer is supposed to do. So we'll be pursuing some avenues on the constitutionality obligation that those officers have separately from this. But knowing that award came out, we had already had kind of some conversations about what we were going to do when it came out. There's no obligation that we, have to immediately take it back to City Council. There's no belief that the City Council will do the right thing. There's no belief that Mayor Johnson won't try and hide it in some rules committee or something else where they're going to let it sit for months on end, if not longer, till a court battle forces it for a vote. So preemptively, the attorneys at my instruction filed another case at Chancery Court yet again, because this city can never be trusted to do the right thing. This should frighten all labor, by the way, that they have the basically ability in their own mind to trump whatever labor law rulings come out because they don't like them. Today it is us, tomorrow it could be any other union if they do not like it. That's just the reality. That's the precedent that they are setting. And I would hope that all of labor steps up and speaks up. We know one union that won't. But anyway, onward we go. We will be back in front of Judge Mullen again on this hearing. We are seeking for the judge to issue an order for the City Council to ratify that provision effective immediately. They will have no choice, or they will be in violation of a court order at that point if they don't, if we are successful in getting Judge Mullen to see our side. We are also seeking a temporary restraining order on all the police board cases currently going on that fall under that provision that go back to September 1 of 2022. So those officers can have the decision on whether to remain at the police board or transfer their case to an arbitrator. So we'll see where that goes next week. I think the irreparable harm argument specifically for the TRO in those cases currently underway is very much more compelling than the healthcare one. And the simple reality is, being a police board veteran myself and knowing how unfair that process is, knowing the scarlet letter that is placed upon you as those police board cases come out, the opinions that get attached to them, those never go away. Thanks to the Illinois Supreme Court's ruling a couple years ago, all of that information will forever follow that officer's name. That is why it is irreparable harm if it continues the way it is, and we are seeking the judge's intervention to stop those cases, which we, by the way, had repeatedly make pleas to the police board. Our attorneys have filed brief after brief requesting stays of proceedings that have been denied by the police board because they are not fair. I mean, their hearing officers are ridiculous, and that's just sadly what we've been facing for far too long. Anyway, that's the two big ones. Parental leave. I know we've had a lot of calls on this too. Here's another example of this city not doing the right thing yet again. This was a mediated agreement, and the agreement was very simple. We would give up medical time like the sergeants, lieutenants, and captains agreed to, and local to the fire department. Regrettably so, but we did because precedent had been set and comparables matter. But in our agreement, we asked for retroactivity for any member back to January of 2023. Whatever time would have been afforded to you in January 1st of 2023 when that policy took effect, then that would have been what you were afforded no matter when, once this was ratified. That was the simple understanding. Calculations might be on a case-by-case basis for some people, depending on when you had your child, even in 2022. But then, after it's ratified by City Council, all of a sudden, now the department has no way to implement the retroactivity part of it because FMLA doesn't have a component to go back once the child turns over a year old. That was never our problem. This is something that they agreed to, but never apparently yet worked out again. It is disgusting, the games they play, the incompetency at City Hall, and specifically 35th in Michigan. Public Safety Headquarters has been on decline ever since there was a merger of police and fire personnel, where more and more civilians have taken spots in that building that do not know the process, do not know terminology, and cannot do their job. And our members, sadly, and I'm sure Pat Cleary of Local 2 would agree with me, I'm sure they're experiencing very similar issues where they're just not getting things done productively like it used to be. This needs to be figured out. That was our stance. You know, Management Labor Affairs tried to basically, I think, get us to back off and say, well, sorry, there's just no way to do this. Well, tough luck, figure it out, because we'll be filing agreements and demanding for another arbitration effective immediately on an agreement that just got ratified by City Council that now they're basically trying to get out from under. It's not going to happen. My recommendation to Management Labor Affairs was very simple. Under the provisions of the Management Rights Agreement, and anybody who works in excess of 10 days, they were getting that kind of separate comp time that was coded separately. It was kind of hierarchy comp time that could be used above all other comp time first and foremost. We told them then give every member affected that doesn't fall under the FMLA guidelines that same coded comp time that they can use up to 12 weeks effective immediately. It's the simplest way to do it. It's not going to get them their federal tax credits, which seems to be all they give a damn about. That's why it's being linked to FMLA, so they can get tax credits from the federal government. Again, it's just a non-stop battle, whether it's incompetence or intentional or a combination of both. The fight will continue. We are not giving up, and I'll keep you posted as we go forward. Everybody have a safe New Year. I'll be in touch.